Bu oturumda kolaylaştırıcılığı ben yapacağım. Oturumumuz ayrımcılık yasağı, zihinsel ve psikososyal engelli çocuk ve kadın hakları. Önce Michael Stein genel bir giriş yapacak. Arkasından Oslo Üniversitesi Siyaset Bilimi bölümünden doktora öğrencisi Kersti Skarsgård kendi hazırladığı bir makaleyi bizimle paylaşacak. Michael?
Thank you, Madam Chair, and good afternoon. This session is on women and children with disabilities, and Ms. Skarstedt is going to be presenting some work on it. But just to put it into context, the Dean very correctly mentioned that the CRPD motto was nothing about us without us, but sometimes nothing about us without us includes everyone, and sometimes it doesn't include everyone. So the convention, as part of a political process, as part of a human process of interaction, tried to be inclusive. And as part of that inclusion, there was, first off, the inclusion of people with disabilities for the first time in UN history as stakeholders participating in the negotiation of a human rights instrument. That was the first time that it occurred. And within that group, people with disabilities formed an international disability caucus and met every morning before the UN met, and we worked out our differences. It was like a family quarrel. So lots of screaming, lots of crying, lots of hand-holding and patting on the backs. But at the end of the 2 hours, there was a unified disability position. Whether ultimately those positions are right or wrong or have traction or need some more pushing is a matter of debate and time and research. But as far as inclusion is always imperfect. Within the disability community, even now, people with intellectual disabilities, people with psychosocial or mental, formerly called mental disabilities, have less voice than others. The articles that we're talking about in this session for women and children were groups that did have the political power and the voice to achieve their own articles. And there was no pushback, there was no controversy about having a special article on women and a special article on children with disabilities. What was lost in the discussions, however, were other groups of individuals with disabilities. So at one point, there was the movement for an article on indigenous persons with disabilities, and there was a draft of an article to include them, but they ran out of funding to attend the UN meetings after the third ad hoc session. And so the only time indigenous groups appear in the document is in the preamble with in one sentence they're mentioned. So when it comes to things like ownership of property, where there are very distinct cultural norms for indigenous groups, or for education, where learning in one's language would have been especially helpful, the indigenous voice was lost. Another group that didn't quite appear, that never appeared, were elders. There's a huge overlap between people with disabilities and people who are older. If we are all fortunate enough to live to old age, we will have disabilities or secondary disabilities. And the issues on legal capacity, decision-making, access to health care, valuing the quality of these individuals' lives, sexual and reproductive health, which is something we don't talk about for either one of the groups, is something that would have been helpful, but the elder community to whom we did reach out decided not to be part of these negotiations. Ironically, the treaty that's most likely to come out of the UN next, if anyone comes out next, will be that for elders, and they're reaching back to the disability community. But be that as it may, we also are missing other groups. But these groups, women and children with disabilities, were included. Remember that the CRPD was passed because disability was absent from the UN and from international programming. The word disability did not appear in the Millennium Development Goals and its work over the years, even though it relates, all the goals relate to disability, poverty, education, HIV, awareness, etc. all have to do with people with disabilities, but disability didn't appear. So one of the motivations for the CRPD's passage was to have a targeted, special, particular human rights treaty that would move and explain why, within the context of disability, these human rights are necessary and how to make them real. If we were talking development studies, we would say that was the targeted approach. But the second level of inclusion at the international level has to do with mainstreaming. How would disability reach out into the UN system, and how would it be made real? And we see this on two parallel levels. Within the treaty itself, we have separate articles on women and children, but when we have an issue relating to women and children, we are not supposed to only look at those articles and remain within those articles. They are horizontal articles. They apply across the entire treaty. Within the UN system, the CRPD clearly relates to people with disabilities, and by the way, those associated with people with disabilities. You have a right as a non-disabled person, if you are discriminated against on the basis of disability, to make a claim. So if you came with me to the movies and they said neither of us can go in, you have a claim. But the question is, how do we also get the CRPD and disability rights in the other committees and across the UN treaty bodies? And that's the subject of the paper that Ms. Skarstedt will be presenting. We had an opportunity very early on in the negotiations. Secretary Annan came and said, we are redoing UN treaty bodies, we are redoing monitoring and evaluation. Be creative. Here's your chance to try to see how you can not only help your own group, but also how to help the UN. So now that we have a CRPD, now that we have a disability-specific treaty, the question is, what's happened next? Have the other individual bodies, the ones who look at rights for women and children, the ones who look at rights for civil political rights, the ones who look at economic, social, cultural rights, have they included disability? Have they embraced it? Or have they not? How much mainstreaming is going on? And so that's the subject of this paper.
This is on? Yeah, good. As Professor Stein told, we have conducted a study on the mainstreaming practices on the UN treaty bodies. And our motivation for doing this study is the historically well-documented exclusions of persons with disabilities. And we wanted to see whether this situation has improved in the 2000s, and particularly whether it has improved after the adoption of the CRPD. So, as you might be aware of, prior to the adoption of the CRPD in 2006, disability wasn't mentioned in any of the UN human rights treaties, apart from 2 articles of the Child Rights Convention. And the UN's own study actually documents that from 1993 to 2002, only 4 disability-related complaints were declared admissible by UN treaty bodies. And only 3% of the Human Rights Committee's concluding observations made any critical statement or recommendations as regards disability rights. And this was the situation even though it was acknowledged that persons with disabilities are experiencing human rights abuses at a substantially higher rate than the non-disabled persons. But there were several important developments in the 2000s. Of course, of most importance was the adoption of the CRPD, which makes disability, of course, an explicit integral part of the UN human rights system. And most interesting for this study is that it sets out a duty to mainstream disability into all policies and practices. There's also a political goal of the UN to mainstream disability, as well as, of course, mainstreaming human rights in general or other vulnerable groups' rights. Particularly important is the General Assembly resolution from 2002. And in addition to this, there has also been inter-committee meetings since 2002 in order to address intersectional human rights challenges. So what we seek to answer then is, to what extent has the UN treaty bodies managed to mainstream disability? And secondly, has the CRPD had any effect? So as we said, mainstreaming means to be fully included into all policies and practices. But it's also of crucial importance that inclusion doesn't only mean that you have to be mentioned. You have to, in addition to, of course, being mentioned, you have to be substantially included. And in order for that to take place, disability must be fully understood as a human rights issue. And to put that simple then, when we talk about human rights, then we know that rights are the same regardless of individual characteristics, and states have a duty to reasonably accommodate disadvantaged individuals in order to ensure that their rights are fulfilled in practice through concrete measures. So this aspect also has to be there. And we can contrast this human rights model of looking on disability against what has been termed the medical model of disability. And in its most sort of extreme version, this is a way of looking at disability that focuses only on the medical condition or impairment of the person as determining the degree to which an individual can fulfill her rights. And that means that it objectifies the individual or treats them as a group defined by their medical condition. So that the focus here is instead of amending or changing the society so as to include all persons, this focuses more on fixing or normalizing so-called deviant disabled persons. So no matter how often disability is mentioned in documents, if it follows this perspective on disability, it is not really mainstreaming. So for this study, first we did a mixed method design. So firstly, we did a quantitative analysis of the number of times disability is mentioned in the concluding observations of the UN treaty bodies prior to the CRPD and after the CRPD. And we did this for 6 treaty bodies. And so in addition to only looking at the quantitative incidence of disability mentioning, we also did a text analysis where we then addressed how do they understand disability and how has this understanding developed. And we did that for 2 treaty bodies. So we operationalized, or in this study, we addressed mainstreaming according to 5 different dimensions. The first dimension being that disability has to be integrated in general concerns, sort of in general non-discrimination policies, so to say. But it also has to be a particular concern in order to address disability-specific issues, or in order to address rights violations against this group, as it's a group that is particularly vulnerable to human rights. And in addition to that, when rights are mentioned, according to a human rights model, they should have, or they have all the same rights. So if we find this to be, or this dimension to be fulfilled, disability should be mentioned in relation to all types of rights, and the level of fulfillment should be the same, so that there are not qualifications put on the level of the rights for one particular group. And in addition, human rights they require duties from the states. We looked at all the concluding observations of 6 treaty bodies from 2000 to 2014. And that makes 1,536 concluding observations in total. And we chose to focus on the concluding observations because these are the most important work of the treaty bodies. This is the result of the human rights dialogue with states parties. So it's in the concluding observations where we really find, this is where the committee expressed their view on the human rights situation in the state, and this is where they come with recommendations. So for the quantitative analysis, we looked at the Human Rights Committee, the Committee on Economic, Social, Cultural Rights, Civil, Political Rights, the third committee, which is the Committee on Racial Discrimination, Committee Against Torture, and then CEDAW and the CRC committees, the Women's and the Children's Rights Committees. And these were the 2 committees selected for the in-depth analysis, because this is where disability is most explicitly acknowledged to aggregate the human rights situation. So let's have a look at the results. This figure shows you the number or the percentage of concluding observation mentioning disability. So what we can see is that there has really been a dramatic increase here in mentioning disability. And if you look at the period prior to the adoption of the CRPD, disability was only mentioned in 16% of the concluding observations, whereas after the adoption of the CRPD, it's mentioned in 60% of the concluding observations. And we also did regressional analysis in order to check whether this is also a statistically significant difference, and it is. So it's not only that there's an increasing trend, but there's actually a significant gap after the adoption of this convention. However, if we move on to looking at the different committees, you will see that the variances here are really huge. So here you have the Child Rights Committee and the Committee on Economic, Social, and Cultural Rights. They have mentioned disability in their concluding observations in more than half of their concluding observations throughout the period. Whereas for the other committees, you can see that there's a substantial increase after 2006. And looking at the Committee Against Racial Discrimination, we actually find that this committee only mentions disability in 2% of its concluding observations prior to the CRPD. And although there is an improvement, they still only mention disability in 26% of their concluding observations. Moving on then to our more in-depth analysis of the Women's Committee first. We find that disability is mentioned, or the numbers rises from 15 to 44%. And looking at how this committee, or whether they address disability specifically, we find that the number rises from 7 to 19%, which is still, there's an improvement, but still very rarely that this committee actually looks at the rights of women with disabilities specifically. The table here just shows you the yearly percentages, and I find it particularly interesting that during the first year, you can see that disability is almost never mentioned at all. But going back to this number, as the committee here is very rarely mentioning the rights of women with disabilities specifically, it actually means that when they mention disability, they mention it together with other groups. So they tend to list the rights of women with disabilities together with other groups. And an example of such a statement, or how they deal with disability when they mention it, will be something like this. This is from the concluding observation on Lithuania in 2008, where the committee notes with concern that vulnerable groups of women, as for example, rural women, women with disabilities, women belonging to ethnic minorities, including Roma women, migrant women, and elderly women, continue to suffer from discrimination in education. So this is a fairly typical example of how disability is addressed. If you look at the other dimensions of mainstreaming, we find that the rights of women with disabilities is typically mentioned in relation to a lack of data. And prior to 2006, it is only mentioned in relation to a few other rights, and that is violence, employment, poverty, and health. So but there is an improvement here, particularly after 2008. However, women with disabilities' political rights are not explicitly mentioned until 2010. And even after 2010, this is not a big concern of the committee. But when they do mention the rights of women with disabilities, they address it in the way so it's clear that they think that the states have the same obligations and the same fulfillment. So there has been a general improvement in the second period, but our conclusion here is that this committee is far from mainstreaming disability. And I think our particular concern is the fact that they very rarely make reference to disability-specific issues, such as, for example, women with disabilities, increased threat against sexual violence from their healthcare workers, institutionalization, accessible workplaces, and so on and so forth. And as long as these issues are not addressed, it makes the committee less able to effectively protect the rights of all women. For the Child Rights Committee, our results are very different. First of all, disability is mentioned in 92% of their concluding observations throughout the period. This is perhaps not so surprising because this is a committee that is actually obliged to write about this or to address disability, since it's specifically mentioned in the convention. So in that sense, we should perhaps expect that the number here should be 100%. As regards addressing the rights of the children with disabilities as a specific concern, we see that the number rises from 29 to 43%. So there's clearly an improvement here. But what is most interesting about this committee, I think, is that it's really interesting to read the concluding observations, because you can really see that this is a committee that has put a lot of efforts into moving away from a medical or an outdated way of understanding disability towards a human rights-based understanding. And the committee is also actually self-reflective of this change. So it has started to tell the state parties that please address disability in a human rights-based model. And adding to this conclusion is the fact that prior to 2007, disability was most often mentioned in relation to education, health, welfare, resources, and poverty. Whereas after 2007, we find that disability is mentioned in relation to all types of rights. Also, there's a move away from the early years where there's a lot of focus on prevention or preventing disabilities. And the language has clearly changed. As the early years, this is not seen as full duties, as the language are just, they use language as we encourage the state, or we encourage the state to consider where possible that you might, perhaps, more this type of language. Whereas from 2006, the committee is much more firm, and they see this as duties, as they say, like, we urge the state party to prioritize these rights. And just to show you like one example of what this might look like, this is from Algeria in 2012, where the committee tells the state to promote the social and human rights-based approach. And in fact, it also tells the state to promote the positive image of children and adults with disabilities. So this committee is able to mainstream disability, at least in some of their concluding observations, and particularly so in the year 2012. But as is true for both of these committees, attention to disability actually varies considerably, even within the same year and within the same committee. So the variances are very huge, not only among the committees, but also within the committees themselves. So this tells us that mainstreaming disability is not an institutionalized approach of the UN human rights treaty bodies, at least not yet. Yeah, I think I'll stop there.
Thank you. I want to thank everyone for being here. I want to thank the organizers. Thank you, Yansu, and to our hosts. It's an incredible amount of work to put together a conference such as this, and it's very appreciated. Thank you to my friend Michael for inviting me. When Michael asks me to go somewhere, I generally say yes. And this has really been a terrific day so far. I think I feel like I've learned a great bit more than I'll be able to give back to you. So thank you. It's really been fascinating. I'm going to be very brief in my comments, both because it's after lunch and I'm sure everybody's a little sleepy, but also because I really want to save time for your questions. I want to start with a theme that Michael started with today, which is the idea with disability law, we're all learning from each other. And I come from a country, the United States, that has not signed the Convention on the Rights of People, has signed but has not ratified the Convention on the Rights of People with Disabilities. But I think in terms of our laws and what we're doing in our country, it's fair to say that in many ways we are trying to live up to the aspirations of the CRPD, just as Turkey is, just as most countries are in one way or another. And so much of what I've heard today reinforces that whatever country you live in, we're really all are facing the same challenges. So it does pay to dialogue and have opportunities like this to listen and learn from each other. The goal of my brief remarks today is to talk about principles of discrimination. So the title of this panel is Prevention from Discrimination, comma, Women and Children with Disabilities. So I'm interpreting that I'm talking about before the comma, just prevention from discrimination generally. I'll primarily be looking at this under international disability law, also giving examples that I'm most familiar with under American disability law. I'd like to talk about discrimination, but also spend some time on the process of how law gets implemented and enforced, that hard work of changing law from just words on a page to something that actually makes a difference in people's lived experience in their lives. So I hope this perspective is able to at least slightly enrich the conversations that we're having today. My background, my training, is as an American domestic commercial lawyer. Before getting into academia, I represented big companies in business disputes. So when I came to international law, I very much came as a skeptic. My perspective as an American lawyer tends to be, who can I sue? How much can I sue them for? What are my chances of winning? And the rest of this stuff that people are talking about is just fluff. But I really, through meetings like this, came to understand and deeply believe in international law as a vehicle by which we can all learn from each other and over time pressure our respective governments to improve what they're doing, in this case, the lives of people with disabilities. And certainly one thing that I think has been clear today, and I'm sure will be clear tomorrow, one point of commonality between the United States and Turkey is both of our countries, it seems like, have had a fair bit of success that we should take pride in. We shouldn't stop working, but we should take pride in terms of improving accessibility for people with physical disabilities. This is something that is vastly improved in my country, I gather is vastly improved here, but that success can in many ways mask problems that people with intellectual, psychosocial, developmental disabilities face, because in many cases, these are harder problems. I know at least in the United States, there's been a lot of advocacy centered on physical disability. And oftentimes when political trade-offs are made, individuals with intellectual disabilities, their interests sometimes get compromised in those political trade-offs. And I'm happy to talk a little bit about that. So let me briefly just talk about American law. American law is strongest on anti-discrimination law. We have very strong anti-discrimination laws, not as strong on some of the second generation or social supports, many of which were the types of things that we talked about in the first panel. So our omnibus disability law that covers a broad range of issues that people with disabilities faced is called the Americans with Disabilities Act. And it's actually in its 25th anniversary this year. So if the ADA was a person, it would have left home already, maybe be in college. Parents are still paying for certain things, but it certainly had some time to grow up a little bit. The ADA is divided into three big parts. The first part deals with non-discrimination in employment. It's called Title I. The real innovation with Title I was the concept, which was later adopted by the UN Convention, the CRPD, of reasonable accommodation, that employers needed to provide at their own expense reasonable accommodation for people with disabilities so as not to be viewed as discriminating against them. So one type of case that we see under the ADA, under the employment provisions of the ADA, is kind of plain old discrimination. I don't like you because you have a disability. A case that illustrates this involves a gentleman named Don Perkel. Michael and I became aware of this case when a friend of ours, Peter Blank, represented Mr. Perkel. Mr. Perkel was someone with an intellectual disability who had worked in a sheltered workshop for a number of years and then got a job at a pizza restaurant, a place called Chuck E. Cheese that parents often take their kids to. And on his first day of the job, at the job, the regional manager, kind of the new boss, came and visited and said, oh, we don't have people like that that work here, and directed the supervisor, you need to fire this person. The supervisor refused. Over time, when the district manager kept telling people that you need to fire this person, everyone else on the job said, no, we're protesting. We're with him, we're with Mr. Perkel. Then finally the big boss came in and terminated him. Mr. Perkel sued. He received $70,000 in compensatory damages and $13 million in punitive damages. It's a lot of money. The higher courts, the appellate courts, later knocked down that punitive damage award. Interestingly, one of the things that the restaurant argued was that as someone with an intellectual disability, Mr. Perkel should not be entitled to this much money because he wasn't really capable of having emotional distress in the first place. So this case, while demonstrating a big problem, blatant discrimination, is somewhat a rare case in the sense that employers have gotten better, even if they are blatantly discriminating, about hiding it a little bit. And a case where the plaintiff actually sued and won. Most cases do not have that happy of a story. And in the United States, like most countries, the employment rates of people with disabilities are far lower than the general population. And when you look at the employment rates of people with intellectual disabilities, they are incredibly lower than the general population. They're almost infinitesimal. One of the issues under the employment sections of the Americans with Disabilities Act, which again I'm happy to talk about in the Q&A, involves reasonable accommodation. And there's not been a whole lot of cases on reasonable accommodation. The big open issue right now in reasonable accommodation is if someone with a disability, because of their disability, are having trouble doing a particular job and they request reassignment to a different job in the same company, perhaps a job that might be sought after by more people. So one example involves a baggage handler who had to work out in the cold in Philadelphia and Pennsylvania, lifting bags. He hurt his back and he requested a transfer to the mailroom, which was nice and warm and people wanted to work there. And it's in that case, the court said he did not get that transfer as a reasonable accommodation. It's still a fairly open question as to whether you get transfer or job reassignment for reasonable accommodation. The second section of the law deals with discrimination in discrimination in government services or activities. So the big areas that this involves are institutions for people with intellectual and developmental disabilities. There's a Supreme Court case called Olmstead, where advocates are able to use that case to close state-run institutions and transition people towards community-based alternatives. Cases under Title II also involve voting cases, which came up this morning, the ability of people with disabilities to be able to vote. Finally, the last area deals with discrimination in privately owned places of public accommodations, restaurants, things of that nature, and most of the litigation there has centered on physical accessibility. One of the large issues under our disability law dealt with the definition of who's covered in the first place, who is considered an individual with a disability. And this took up a lot of time and energy working through the courts. Now, I think one important observation for today's conference is, for the most part, there was never any disagreement in the courts whether individuals with intellectual disabilities were covered. Almost every court said yes, of course they are. But people with physical disabilities were increasingly having a harder and harder time getting covered under the law. So much so that advocates went back to Congress to get the law changed. When they got the law changed, they worked to expand the definition of disability, to make sure that it included more people. One of the trade-offs in doing that was there was a provision in the original law that said the following. It said, people with disabilities are a discrete and insular minority. Now, that may not mean much to you, but in American constitutional jurisprudence, those are very, very, very important terms. It means that people with disabilities are entitled to our highest level of constitutional protection. When advocates went back to, and let me say, to my judgment, I know the judgment of Michael Stein, that absolutely covers people with intellectual disabilities. People with intellectual disabilities are a discrete and insular minority that have been subjected to terrible discrimination through our history. When Congress amended the ADA, they broadened the law and they removed that section from the law. They took that out. So the compromise was made to make the law much bigger, but removing the protection for those groups. We have several other laws. There's the Individuals with Disabilities Education Act, which the very competent person sitting to my left will talk to you about when I'm done. We in the United States are very good at passing laws. But like anywhere else, our laws are not self-executing. They do not enforce themselves. So it becomes the job of individuals to enforce their own rights, and in many cases, the role of lawyers and law students to help them enforce their rights or find other ways to make them meaningful. In the United States, there are two types of lawyers that will represent people with disabilities. The first are public lawyers, lawyers that work for different levels of government, and each of the parts of the law that I talked about have different government lawyers that they are assigned. Their job when they wake up each morning is to enforce those disability laws. But those agencies have limited resources, and they are never going to be able to represent everyone who is a victim of discrimination. In terms of how much work those public organizations put in, like anywhere else, it depends who are the politicians in charge, who is the president at that moment, and what are that president's enforcement priorities. The other type of lawyers that bring these cases are private lawyers. And we are very lucky in the United States. There is a dedicated private bar, many of whom work exclusively on representing disability rights plaintiffs. And we're very fortunate in that regard. And these lawyers, over time, have gotten increasingly sophisticated about how they do their work. And they've really built up their networks and worked together across the country in ways that make them more effective. Nevertheless, it's hard oftentimes for these lawyers to get paid for their work, which sets up a barrier to them being able to do this type of work. And often they need to rely on fundraising, trying to get private donors to finance litigation, lawsuits, to help people with disabilities. But we see some really creative work in what they're doing, and when you talk to and interview these lawyers, they're really trying to change hearts and minds. They view their job as more than trying to win a specific case. They're trying to use law to educate the public towards a more accessible society with varying degrees of success. Let me shift now and conclude with international law and efforts in the United States, like elsewhere, like in any country, to try to measure up to the level set by the CRPD. In 2008, which is now a long time ago, Professor Stein and I were asked to write a report on how United States law measured up to the CRPD. And I think the idea was that at some point, some administration might be interested in signing and ratifying the CRPD, and I think the hope was that they could pull our report off the shelf and that it might be useful. It sat on the shelf for a long time, gathering dust. We concluded that, as a general matter, the aims of the CRPD were consistent with U.S. disability law, and that for a majority of the articles in the CRPD, U.S. law could be viewed either as on the level with the CRPD or capable of being brought up to the level with more rigorous enforcement or implementation. But we said there are some articles where there are certainly gaps. So just to give you a few examples, Article 19 on the right to live independently and be included in the community. We have Supreme Court cases that say individuals with intellectual, individuals with psychosocial disabilities have a right under our statutory law to receive services in the community, to not be put in institutions. But even that right is qualified by it can't be too expensive, it can't be too hard for the state to administer this. And interestingly, and this came up this morning, in the campaigns that are going on right now to enforce this right, one of the biggest vocal opponents of this process of deinstitutionalization has been the family members of individuals who reside in institutions who feel most comfortable with that arrangement. And oftentimes that is because the social supports that are needed to enable individuals to live productively in the community simply aren't there. It's much easier to close down institutions than it is to give individuals the support they need to thrive in the community. Article 23, respect for the home and family. At least in our system, it's individual states, for the most part, rather than the federal government that govern family law issues. So you still see awful state laws that impact the rights of parents with disabilities, that restrict people with disabilities from getting married. Finally, on Article 27, work and employment. Again, while the United States law is quite strong on anti-discrimination, our law currently does not provide equality measures such as vocational training, and there's very little in the way of a federal job training program for people with disabilities. And our health insurance system and our public benefits often operate to create a disincentive for people with disabilities to go out and work even when they have the ability to do so. So again, I'm gonna conclude there, and again, thank you for having me, and say I'm happy during the Q&A to talk about this or any other related issues. I really look forward to your comments and questions.
Thank you very much. At least I will have a million questions to you. Julie, please.
Sorry, does it box you out there?
Why don't we switch?
Okay. Just get a little closer to the microphone. Great. I want to start by thanking the organizers as well. Jansu for having me, Michael Stein for inviting me. It's really a great honor to be here and to be a part of this incredible dialogue. It's also very wonderful to see that children are being included in this discussion. So when Michael mentioned that first part of the comma, I'm focusing on the last part of the comma. But this is often a group that does get left out of the conversations, predominantly because they don't always necessarily come with their own voice, so people are speaking for them. They're very vulnerable and often subject to multiple forms of discrimination. So as we're looking to build a successful society, it is critical that we do include children as a part of this conversation. I'm going to start by talking about the work that I do in the United States with children with both intellectual and social emotional disabilities. I'm going to begin by providing a little bit of my background, which will hopefully help you understand where I'm coming from, and then give you the legal framework under which I work and talk about how these laws are enforced and some of the challenges to enforcement of these laws. I thought it was important to give you a little bit of my background because I see myself as an academic, but almost more as a lawyer. I run a clinical program at Southwestern Law School in Los Angeles where I'm teaching or training law students to be lawyers, and the types of cases that we work on are representing children with disabilities and ensuring that they receive their rights in the educational system. Because I'm taking on actual cases, I feel much more like a lawyer than an academic. The other piece that we do is also ensuring that children with disabilities are free from discrimination in the schools that they are attending. So with that, I'm going to start by providing you with a little bit of the legal framework. I'm going to start with the international context, since that's where we're focusing most of our discussion on today. There really are two conventions that have already been mentioned, but that deal with children with disabilities. There's the Convention on the Rights of the Child, and then the Convention on the Rights of Persons with Disabilities. So in 1989, the Convention on the Rights of the Child was the first binding instrument in international law which really dealt comprehensively with the human rights of children and is really notable, as was mentioned previously, for its inclusion of an article that specifically is concerned with the rights of children with disabilities. The CRC identifies 4 general principles that provide the foundation for the realization of the other rights: non-discrimination, the best interests of the child, survival and development, and respect for the views of the child. Specifically, Article 2 of the Convention on the Rights of the Child expressly prohibits discrimination on the basis of disability. And I know that that was the focus of the remarks earlier. We saw in the concluding observations how many times disability was mentioned. This principle is really motivated by the recognition that segregated or separate facilities for education, healthcare, recreation, and all other aspects of human life on the basis of disability can create exclusion. With regard to the CRPD, all of the provisions apply to children as well as to adults, but there's one specific provision that applies to children, and that's Article 7. And this really affirms the fundamental rights of all children with disabilities and provides that children with disabilities must be included in important decision-making. There's another article, Article 24, that reflects a commitment of inclusive education as a goal and discusses the importance of having education address a child's unique needs. I wanted to provide that as the framework because, as you all know, that the U.S. is not necessarily a party to these laws, but the laws do really influence the laws that we have in the United States. I think we see a lot of the same principles embodied in our U.S. laws. So the primary law under which I do my work is the IDEA, and that's the Individuals with Disabilities Education Act. And this is really, I think, one of our strongest laws for children with disability. It provides that all children with disabilities are entitled to a free, appropriate public education in the least restrictive environment with supports and services that are designed to meet their unique needs. And I'm going to break that down a little bit because there are a lot of parts to that. So the first part is the free, appropriate public education. And what that means is that all children, regardless of whatever disability they may have, are entitled to get to an education and to be educated in a public school, and whatever they need is going to be free for them. There's the second provision that says in the least restrictive environment, and that's where we're really looking at the mainstreaming provision and ensuring that children with disabilities are included in regular education classes to the extent possible. And then there's the portion of supports and services. And what that tells us is that students with disabilities are able to receive different types of services, things such as speech therapy, physical therapy, it could be perhaps mental health services, but things that really enable children to succeed in the classroom. And these all need to be tailored to a child's individual needs. And if a school district fails to comply with any of these laws, there are mechanisms by which parents can hold the school district accountable. They're able to bring lawsuits against the district, but the remedies that they receive are somewhat limited. And I'll talk about this a little bit more, but what parents are able to receive is what we would refer to as compensatory services. And what that really means is that the district needs to make up the services that the child has missed out on. So we're not really looking at any kind of monetary damage. You're not going to walk away with that huge $13 million award that we heard about before. It's really going to be in the form of some type of therapy. It could be what's termed education therapy, which is almost like tutoring, but really it's looking at how we can make the child whole for whatever they missed out on. The other law that I often work under is Section 504 of the Rehabilitation Act, and I think of this law as more of an anti-discrimination provision. It provides that no person with a disability can be excluded from participation or be denied any benefit of any program or activity that receives money from the U.S. government. And what this means when we're looking at discrimination is that if a child is excluded or provided with any inferior or deferential treatment as a result of their disability, then the school district could be held responsible for those actions. Under this provision, Section 504, school districts still have an obligation to provide a free, appropriate public education, just like they do under the IDEA. But the biggest difference between the IDEA and Section 504 is that the IDEA actually provides funding to educational agencies. And it attaches conditions to receipt of these federal funds. So basically, if an educational agency is going to receive money, then they have to do certain things. They have to make sure that they're providing different types of classrooms available to all children with disabilities. They have to ensure that children with disabilities receive the supports and services. So those therapies that I was talking about, they need to make sure those are available. They need to make sure if a child needs an aid, that that aid is available. And all of that is conditioned on receipt of them receiving federal funding is a condition of them actually providing those services. Section 504 doesn't have any funding specifically that's attached to it. What it does actually is it says that if you discriminate, we'll take away any of the federal funds that you're receiving. So it kind of uses that as more of a stick, if you will. Under Section 504, there is a mechanism by which school districts can be held accountable as well. People are allowed to bring complaints against any school that is found to discriminate against children with disabilities. And these complaints can come from parents, they can come from students or advocates. The mechanism by which you'd bring a complaint My apologies. That's perfect. I need to remember that someone has to translate everything that I say, so I have to speak slower. Apologize for that. So under Section 504, a complaint can be brought to an organization, which is, or an entity rather, the Office of Civil Rights. The Office of Civil Rights will then investigate the complaint that's brought. There's no lawsuit that's filed where you have an actual hearing, where the judge would hear evidence. That's something that we would have under an IDEA case. Here, it's more done on paper. You file a complaint, and then an officer would go and investigate the complaint. Initially, the officer would try to bring the school district into voluntary compliance through negotiation of a corrective action agreement. But if that's not possible, then the Office of Civil Rights would initiate an enforcement action by initiating a proceeding to terminate the financial assistance or that funding that I was talking about to the school, or even possibly refer the case to the Department of Justice. But I'll talk about the difficulties with that momentarily. Both of these laws are great on paper. The IDEA provides wonderful benefits for students with disabilities, but the implementation of the IDEA is very dependent on funding. Many school districts will argue that they don't have the funding to provide everything that's required by law. This statute, the IDEA, was written so that it could be enforced by parents. And while that can be a great benefit because it seems like anyone should be able to hold school districts accountable, it can actually be a limitation. One, many parents are not aware of their rights, and even if they are aware of their rights, they don't necessarily know how to go about enforcing them. Or they may not have the capacity to bring a lawsuit. They might not have the resources. The law does allow parents to bring a lawsuit on their own without a lawyer, but if they don't have a lawyer, they're at a great disadvantage. Because the school district will typically have a lawyer, they'll also typically have expert witnesses that will come and support all of the things that they're doing and the reasons behind why they're doing it. So if a parent goes to court without having that expert witness, it is really difficult for them to prove their case. So what ends up happening is we have a situation where the law can be enforced really well by those families who have resources. And the families who might need this the most don't have the resources necessarily to enforce the law. With Section 504, it's another great provision that would seem to be a wonderful deterrent from schools engaging in discrimination. The difficulty with this law is also with enforcement. One is an issue of awareness. Again, a lot of parents don't realize that this is a tool that they have to utilize. And even if they do, they really need to have a lawyer bring this complaint on their behalf. With this provision, there's no monetary award that it attaches to a complaint. Typically what happens is a complaint would be filed. Once it's investigated, a school district really will get a sort of slap on the wrist. There's nothing strong that happens to them. I mean, we might think because you can take away funding that that would be a really great stick or preventative measure, but what we find in reality is that most of the school districts will just fix whatever they've been doing for that situation and then continue on in their bad practices. Unless there was some big media attention or something else that resulted from it, typically there's not enough to change behavior there. So with that understanding of what the law looks like, I want to spend just a few minutes talking to you about what this looks like in my casework. So one case that I brought under the IDEA was a child who was about 14 years old who hadn't been doing well in school for a number of years. He had been passing from grade to grade, and if you look at the fact that he was passing as a mark of success, well, fine, he was doing okay. I ended up getting his case because he got into trouble from school, and he had gotten into an altercation with a few boys, and it came from him hanging out with the wrong crowd. And the school was trying to exclude him from being a part of that campus. So the family was looking to us to hopefully help him stay in school. He was not at this point eligible for special education under the IDEA. We started investigating his case and asked for an evaluation. And after an evaluation was done, we realized that this was a boy with an intellectual disability. I think, to borrow from the phraseology that was used earlier this morning, we would consider him very high functioning. So he was, one of those individuals that could do really well in general situations, and in many ways his disability was overlooked for a lot of years. And it wasn't until someone started digging deeper that we got him eligible, got him some supports in the classroom, and then he started making progress. And he actually was doing well in school. He ended up, with a good group of friends, I think, that had positive influences on him, and went on to graduate from high school, which is a great success story. One of the Section 504 cases that I have right now actually going on is representing a boy with autism who has a lot of behavioral challenges. Most specifically, he'll say things that people might find offensive. He kind of blurts things out, but really does not understand the social implications of the words that he's using. What the school, he has an aide throughout the day who's with him to help correct his behavior. What the school is trying to do is they're trying to say that every child can be dropped off at 7:30, even though school doesn't start until 8:30. But this boy, because his aide isn't with him, he's not allowed to be dropped off until 8:30. So we saw that, recognized that right away as a form of discrimination. And this is one that we're in negotiations with the school. Rather than filing a complaint, we felt like it was better to start there and try to work out some form of a settlement rather than go through the complaint process. In one of the discussions I was having earlier, we were talking about the cultural differences of bringing a lawsuit and how there are a lot of barriers to bringing a lawsuit, that it's not always seen as favorable. In this case, one of the reasons that we decided not to go that route is the time that it would take to actually investigate the complaint, and by the time the complaint was investigated and action was taken, at that point, I think that he probably would be done with his school year. So we thought that hopefully this would be a better way to get things settled. So I think we're almost there. Hopefully I'll have good news to report there soon. But in thinking about what I have to offer to the discussion today, one of the biggest things is that we can effectuate change through education. And if we can start by including children with all disabilities, but particularly with intellectual disabilities, in school and in the classroom, it creates a culture of acceptance and ultimate integration. By highlighting some of the benefits of the American laws, my hope is that it will spark a dialogue about ways that laws of integration and inclusion can be strengthened here and in other countries. Thank you.
Tüm konuşmacılara çok teşekkür ediyorum. Toparlayacak bir iki husus söylemek istiyorum. Ondan sonra sorular için sözü size bırakacağım. En sondan başlayayım. Hukukun kullanılması meselesi önemli bir mesele bizim için. Özellikle de hak ve özgürlüklerden kişilerin fiili olarak yararlanmasını sağlamak için. Biz hukuktan yararlanmak deyince genelde dava açmayı anlarız. Ancak birlikte çalıştığımız sivil toplum örgütlerinin çoğuyla şunu yapmaya çalışıyoruz. Örneğin zihinsel engelli bir çocuğun okula kaydedilmemesi riski söz konusu ise aile veya sivil toplum örgütü üyelerinden biri çocukla birlikte gittiğinde kanunla birlikte Birleşmiş Milletler Engelli Hakları Sözleşmesi'ni götürdüğünde genelde karşı taraf eğer çocuk okula kaydedilmezse hukuken bir sorun çıkacağını düşündüğünden, yani karşı taraf haklarını biliyor, bunu gördüğünden genelde hukuki bir sorun çıkartmamayı tercih ediyor. O nedenle Türkiye'de dava açmaktansa dava açma kapasitesine sahip olduğunuzu, yani bunun bilgisine sahip olduğunuzu göstermek çoğu zaman çok daha fazla etkili oluyor. Engellilik meselesinin bir insan hakları meselesi olduğunu daha önce söylemiştik. Bu çerçevede iki ilkenin altını çizmek istiyorum. Birini daha önce söyledik. Bütüncüllük meselesi. Özellikle Julie'nin belirttiği bazı meselelerde bunu görmek mümkün. Bazen hukuk bir meseleyi düzenliyor ama o düzenleme istendiği gibi yürümediğinde alternatifinin ne olacağını söylemeyebiliyor. O nedenle tüm alanların bütüncül olarak düşünülmesi gerekiyor. Bir. İkincisi, hukuka uygun davranmanın maliyeti bazen hukuka aykırı davranmanın maliyetinden daha yüksek olabiliyor. Bu özellikle Michael'ın belirttiği reasonable accommodation olarak sözleşmede anılan, bizim makul düzenleme olarak çevirdiğimiz hususta söz konusu. Bir işveren veya bir okul öğrenciyi veya çalışanı sistem içerisine katmak için yapacağı masrafı yapmadığında bunun bedeli çok daha azsa yapmamayı tercih edebiliyor. O nedenle bizim yaptırım dediğimiz şey, yani hukuka uymamanın bedeli, bu her zaman parasal bedeli olmayabilir, hukuka uymanın bedelinden çok daha yüksek olmalı ki kişiler hukuka uymayı tercih etsin. Türkiye kontekstinde bunun örneği engelli bireylere ilişkin istihdam kotası. İşveren engelli bireyi çalıştırdığında 3 lira maliyeti olacaksa ama çalıştırmadığında 2 lira maliyeti olacaksa çalıştırmamayı tercih edebiliyor. O nedenle de bu bütüncüllük vurgusunu özellikle yapmak istiyorum. Sistemin doğru çalışabilmesi için kanun koyucunun her zaman şöyle olursa ne olur, böyle olursa ne olur diye alternatifleri mutlaka düşünmesi gerekiyor. İlk konuşmacılarımızın konuşmalarına geldiğimizde burada da özellikle kadın ve çocuk meselesinin engellilik içerisindeki yeri veya engellilik meselesinin kadın ve çocuk alanındaki yeri meselesi. Bundan sonraki kısmı İngilizce olarak devam edeceğim, kulaklıkları olmadığı için. I will have one comment and actually a question for you on what you were talking about. When it comes to Human Rights Committee, Committee on the Economic, Social and Cultural Rights, they don't really focus on disability issues. But I think we should also look at the CRPD committee and how they approach the issue of women, for example, violence against women with disabilities or violence and harassment against children with disabilities, different disability forms as well. So it's not only the others not looking at disability issues in details, but I think we should keep an eye on the CRPD committee and see whether they really understand the women's issues and the problems of women with intellectual disabilities or children. So I think expertise in one area or focus in one area will not be enough on either of these sides.